Have you clearly communicated to those in the room who traveled from North Carolina that you did not have the support on the Senate floor for confirmation?
Senator, I can't recall every conversation, but I did understand that you made public comments relating to this.
It wasn't a public comment. It was a formal communication to the White House.
He sexually assaulted one of the patients. She had Alzheimer's. Do you remember how old she was?
I do not remember, but I do know she needed to be in a nursing home and was incapacitated.
She was 93 years old. You gave him 11 months and 15 days, didn't you, for assaulting this woman?
If that is what your records show, I have no reason to disagree with that.
Would you lie to this committee to get confirmed?
No, Senator.
You just did, didn't you?
I don't believe so, yeah.
You refused to represent the state of North Carolina in defending the law with respect to abortion, too, didn't you?
Senator, I had no role.
You knew nothing about it.
Well, I was aware of it happening,
Right.
And I'd just like to go back and maybe respond to the process. The way this process played out is that the White House, we put together, Senator Budd and I would like to seek unanimous consent to put forth the letter from Senator Budd opposing
without objection
Mr. Park's nomination. We started through this process with the White House Ledge Council several months ago. We established a committee. It was a bipartisan makeup of a committee in North Carolina endorsed by 2 Republican senators, and we sent forth 4 nominations. The White House responded that none of them were acceptable. In fact, they went so far to say as not only was one judge who was a 13-year Democrat, a very well-respected Democrat magistrate judge, that not only did they reject our nominees for the circuit court, but they would also not even consider some of them for a potential district court opening. Okay. They send forth a list of 4 people, up to and including the person who ran against Senator Budd in the general election. Somebody I would consider to be arguably partisan by definition. They went through a Democratic primary, they're running for the Senate, but the White House, thought that would be somebody that's a valid list of 4 people that I should choose from. So I question the sincerity of the White House of the process. On your point about the blue slips, you know I'm in. I signed a letter to actually not vote for the filibuster and sent it to President Trump, along with a lot of my colleagues here who ultimately recanted on that letter and voted to nuke the filibuster. If somebody wants to join me in the moral high ground on being bipartisan and consistent, welcome. But for anybody to say that somehow this process was just ivory perfect doesn't make sense to me. And what doesn't make sense to me is when the 4 nominees that we put forth were rejected out of hand, and I communicated 2.5 months ago to the White House that their 4 nominees were rejected out of hand, why are we putting this nominee through this process? I wonder whether or not, when you were seeking the support of some friends that I see in the room, whether or not they were aware that 2.5 months ago I had secured support to block this nomination. If they had, why didn't you call me? And if you didn't, why didn't they inform you? And when I have an opportunity to ask Mr. Park questions, I'm going to ask him if he's been aware for 2.5 months that he did not have support on the floor to get confirmed. But I'm going to reserve maybe the balance of my time and defer to my Republican colleague, Hawley.
Let me ask, before that happens, do you want to ask a question of the nominee?
I'm going to be here for the duration, Mr. Chair, so I can wait until the end.
Well, this is the first round, and I'm recognizing you for that purpose.
I'll wait for the second round. We'll defer to the next Democrat.
We don't have a second round scheduled. We have a second panel scheduled.
I'll take this time.
He offered it to Senator Hawley.
Well, no, let me just ask the question now. Mr. Park, have you been aware that since April the 17th, I communicated to the White House Ledge Council that it was unfortunate that my 4 nominees were rejected out of hand and that we did not find their 4 nominees as satisfactory, and we needed to get back to work, but that I had confirmed support of my Republican colleagues and sufficient numbers of Democrats to block your nomination on the floor. Were you aware of that as early as May?
Senator, I'm not precisely sure when I was informed of that, but the White House did inform me of that at some point before we met.
Do you know whether or not when seeking support to come to this hearing, did you communicate to those that you've asked to provide support in this hearing, were they fully informed that I had secured support to prevent your confirmation on the Senate floor?
I'm not aware of every communication that I had, Senator. I had
with
many
respect to
conversations.
communications that you have had, have you clearly communicated to those in the room who traveled from North Carolina that you did not have the support on the Senate floor for confirmation?
Senator, I can't recall every conversation, but I did understand that you made public comments relating to this, and at some point I was hoping it wasn't me, but I was
and Mr.
informed.
Park, it wasn't a public comment. It was a formal communication to the White House at 6:03 p.m. on April the 17th. And so I guess that I'll take that as a maybe, and at some point, maybe the people that you pursued or that those who were behind you pursued did or did not know until they heard me say this in the room. I guess I will never know. But Mr. Park, understand, this is not personal. I don't take things personally. It breaks my heart to have your family members in the room to maybe hear for the first time that this is the case. But I will continue to do everything I can, should you get reported out of this committee, to block your confirmation on the floor, respectfully.
Would you lie to this committee to get confirmed?
No, Senator.
You just did, didn't you?
I don't believe so, yeah.
I've spent a lot of time studying your record. You're a bright young man. You're an activist, aren't you?
Senator, I don't think that's a fair description of my record.
Okay. You have a history of substituting your judgment for your client's interests. My impression of your record, and I've studied it carefully, is that when you think you're smarter and more virtuous than your client or the law, you substitute your own judgment. And that's a dangerous thing to do if you're a federal judge. It's a dangerous thing that you have done as a Solicitor General. Berger v. North Carolina, State Conference of the NAACP. The North Carolina legislature, elected by the people, passed the voter ID law. NAACP, as is its right, filed suit to challenge it. You were supposed to represent the people of North Carolina in the legislature. You dumped on the case, didn't you? You purposely tried to lose, didn't you?
Senator, not at all.
Well, your opponents, NAACP, filed a multitude of affidavits and expert opinions. You declined to offer a single expert witness affidavit, didn't you?
Well, Senator, let me clarify. I had no role in the trial proceedings. I'm an appellate lawyer.
Did you and your office decline to file any affidavits whatsoever?
I don't recall, Senator. I believe that is accurate, but again, I was not involved in the case at the time.
I checked. You didn't. The district court ruled for the NAACP. You didn't seek an injunction or a stay, did you?
I believe that's correct.
Yeah,
yes.
I know it's correct. You dumped on the case.
Senator, I don't think that's a fair characterization of what happened.
I do, and I think the facts bear it out. So then you take it up on appeal. In fact, the leadership in the legislature, because you dumped on the case, they tried to intervene. Said, our lawyer is not representing us, for God's sakes. They tried to intervene, the judge said no. So the case goes up on appeal to the Fourth Circuit. The Fourth Circuit reverses the district court, even though you and your colleagues tried to lose the case, and you did. It goes up to the Court of Appeal. Court of Appeal and the Fourth Circuit rules in favor of the state. You're representing the state. You tried to appeal the decision that was in your client's favor, didn't you?
Do you mean the intervention dispute, Senator?
No. You tried to reverse the Fourth Circuit that ruled in your client's favor.
Senator, that is not accurate.
Yes, it is. Yes, it is. You filed a petition for an en-banc review to overrule the panel opinion.
Senator, that's actually inaccurate. That's the intervention dispute. My office, there were two parallel appeals, and on the merits of the appeal, which we did appeal the non-entry of a preliminary injunction, and we prevailed on that appeal, working with the legislative defendants in that case.
Okay. School funding case. You were supposed to, you and your colleagues were supposed to represent the state in that case. Low-income school districts, as happens in most states, sued the state to force the Republican legislature to increase their funding. You're supposed to represent the state. You and your clients dumped on your client. You and your colleagues dumped on your client again, didn't you?
Senator, as Solicitor General Brasher told this committee a few years ago, the Solicitor General does not make those decisions.
Right. This is what you and your boss said. And it's your boss's words, but I didn't see you objecting. He said, today, quote, I'm going to quote, today, lawyers from my office are arguing that we must invest more money in our public schools so our students can get sound basic public education. Y'all dumped on your client. You did the same thing. You refused to represent the state of North Carolina in defending the law with respect to abortion, too, didn't you?
Senator, I had no role.
You knew nothing about it.
Well, I was aware of it happening,
Right.
Okay. Senator, the Attorney General.
Look, you're a smart young man. My esteemed chairman's going to cut me off, but you can't. I know you're smart, and I know you think you're more virtuous than other people. But that's a dangerous trait when you're a federal judge. I just don't think you're mature enough to be a federal judge. I don't think you'll follow the law. I think you'll try to bend the law to what you think is right. And that undermines our federal judiciary. And I don't think you've been candid with this committee. You know that, and I know that. And your record knows that.
Do you want to complete your answer to any of those questions?
Thank you, Chair Durbin. On the voter ID dispute, I think that's a helpful illustration. I had no role in the trial court proceedings. I don't even believe I was updated as the litigation in the trial court was happening. But when we had an adverse order, my role was to play a part in authorizing the appeal. I did authorize the appeal, and lawyers in my office prevailed in vacating the injunction against the voter ID law that had been entered by the district court. There was a side dispute on intervention as to whether the legislative leaders should have been allowed to intervene. I think 2 points there. We never opposed their right to intervene. I told the Supreme Court that in a brief that I signed, that we do not oppose their right to intervene. And we also said in a brief that I worked on and authored large parts of, I substantively defended the voter ID law. I explained that the voter ID law was compliant with Supreme Court precedent and that we were prepared to defend it below and that we would do so. And I remember drafting this part of the brief, extensive argumentation about why the voter ID law in North Carolina was constitutional.
Mr. Chairman, can I respond? Please?
Sure, go ahead. Take 30 seconds.
I will. Look, Counselor, those are pretty words, but I'm going to tell you something. I've studied your record. And if I hired you as a lawyer and you did to me what you did to your client, the people of North Carolina, I'd have brought you to the Bar Association. I'd have filed a complaint against you for violations of the Code of Ethics.
I've never heard of a competency court. Tell us what it is.
We are the first in our state, and hopefully not the last. So every day in jail, there are people who are incompetent to stand trial for a variety of reasons: serious mental illness, autism, intellectual disability, dementia, and traumatic brain injury. These are people who will never be able to stand trial. To address their needs, you need to have a deep understanding of the law and the available programming. To address this, I created Competency Court, which is a centralized location with an assigned knowledgeable district attorney and public defender. Together, we have been able to efficiently and effectively address these cases in a way that has benefited the community because we protect society from those that are a danger to others. We help the individual who is incompetent and struggling by helping provide them the appropriate programming and placement. And this ultimately helps law enforcement, who are the people on the streets who are dealing with these incompetent individuals in the community, by providing the appropriate services.
What training and skills have you gained in the process?
Senator, the opportunity to train and get to know the magistrate judges in this country has been one of the greatest privileges of my life, and I learn as much as I teach to those magistrate judges who come to new magistrate judge orientation, which I have taught at for the last 10 years. It is a great opportunity to share ideas, learn how other things are done in different districts, and it's a collaborative process. I share what I've learned. The other members on the committee who taught with me would share what they would learn, and we would learn from those judges. It's a very collaborative process.
The obvious question that's asked of all is whether you can show balance in the courtroom, whether you lean one way or the other, the prosecution or defense. What's your response?
My response is that a good prosecutor shares many traits in common with a good judge. A good prosecutor's job is not to gain convictions, but to seek justice. A good prosecutor approaches every case with an open mind, following the facts wherever they may lead, with no particular outcome in mind. And a good prosecutor is fair, always ensuring that the defendant's Fourth, Fifth, and Sixth Amendment rights are upheld.
Tell me about your background and how you believe that you've managed to make it to this point.
Thank you, Chair Durbin. I started off my career after law school practicing criminal defense for 4 years in Milwaukee. That was an experience that had me in court every day. That was invaluable for a young lawyer. And I did that for about 4 years and then moved back to Green Bay, where I've been practicing civil litigation for the past 17, however the math works out, 18 years.
Who is Brian Labus, L-A-B-U-S? Is that name ring a bell?
Brian Labus, if I am remembering,
Labus.
if I am remembering correctly, since I had 2 years in criminal, about 2,000 cases assigned to me, I believe he was the first human trafficker case we had in Montgomery County. Am I remembering that correctly, Senator?
Well, he was 25 years old. He was a nursing assistant.
Oh, that's a different case. I do recall that one. Thank you,
Yeah,
sir.
a nursing home. He sexually assaulted one of the patients. She had Alzheimer's. Do you remember how old she was?
I do not remember, but I do know she needed to be in a nursing home and was incapacitated.
She was 93 years old. He's 25. He gets her alone. She's got Alzheimer's. And he molests her. This meathead made bail. And because he's like a rock, only dumber, he immediately goes out and drives while smoking dope. He gets arrested. And he came before you for sentencing. Do you remember what sentence you gave him?
I do, and my recollection of the facts is slightly different. My recollection is his DUI arrest was after my sentencing, but regardless, you are correct, he had the DUI. This was a negotiated sentence in this case.
What sentence did you give him?
I do not recall the terms of the negotiation. I do remember it was a negotiated sentence, and I do have...
You gave him 11 months and 15 days, didn't you, for assaulting this woman?
If that is what your records show, I have no reason to disagree with that.
And he grinned, according to the news reports. Grinned at you. You remember that?
I do not recall that. I do have recollections of this case, and if I may, Senator, it is a case in which the Commonwealth had...
Yes, ma'am, but I've got to... I don't want you to take all my time telling me about the case, because I've looked at the case. For the DUI, after this meathead assaults a 93-year-old Alzheimer patient, you gave him 11 months and 15 days. For the DUI case, you gave him 3 days to 6 months.
Senator, the DUI was not in front of me. I was out of the criminal division by then, and I believe that went to a judge that took my cases when I was transferred to the civil division.
Ms. Perry, tell me the difference between res judicata and collateral estoppel.
Collateral estoppel is also known as issue preclusion. Res judicata is also known as claim preclusion. In issue preclusion, the question is whether the parties have previously litigated to their merits and finality the same issue, in which case they would not be allowed to relitigate the issue. In claim preclusion, the question is similar, whether the parties have litigated to finality on the merits claims, and they would not be allowed to relitigate those.
Okay. Tell me the legal meaning of present sense impression.
Present sense impression is an exception to the hearsay rule. And in present sense exception cases, it's the general idea behind the exception is that a person is unlikely to lie if they are simply giving their present recollection of exactly what is occurring as it is occurring. And therefore, those statements are allowed to be used in evidence, even though they are, by definition, hearsay.
Very good. Tell me, what is, we all pay taxes on income. I know you do because the FBI checked. They do a thorough background check. And I do too. What is income?
Well, the IRS regulations are extremely complex when it comes to
what is income?
Describing income, but basically it is anything of value that you receive throughout the year. So it could be gratuities, it could be wages.
Well, what if I'm asking you how you go about analyzing this. Let's suppose Senator Durbin starts a new company and he takes it public. And I decide to buy some stock because I believe in Dick Durbin, and I buy it at 10, and it goes to 20, and I'm feeling all warm and toasty, but I don't sell it. I want to just because I think it's going to go to 30 because I believe in Senator Durbin. Can government tax me even though I haven't sold it?
I am by no means a tax expert, and I would like no one to rely upon this tax advice. My understanding is that would be an unrealized capital gain, and you would be taxed upon it at the time that it is realized. But again, I am not a tax law expert.
Why is that? I mean, what's the basis for that?
Why am I not a tax law expert?
What's the basis for that?
I believe the basis for that is that those are somewhat imaginary gains that can rise or fall as the market rises or falls, and so they tax you upon it at the time that you actually realize that interest.
Okay. Gentlemen, I'm sorry I'm out of time.